Hi, everybody. I am attorney Sonia Muñoz Gallagher. I am the owner of Family Wealth Law, and I have received a lot of really good feedback on the FAQ series. So I'm going to continue it and hopefully it answers your questions. And of course, you are welcome to comment down below or to email me directly with your questions. You can email me at info@familywealthlaw.net. So let's see. What is the question for today? Okay. What documents need to be recorded after I create my trust? Do I need to record my trust? I get that question often. What documents actually get recorded? All right. So we're going to walk through this in plain English. One of the most common questions I hear after clients sign their trust is, Sonia, do I need to record my trust with the county or with the state or with the court system? The answer is no. No, you do not record your trust. Your trust is a private legal document. So it stays with you. It is private. It does not get recorded. It's one of the major benefits of the revocable trust. The revocable trust is also called a revocable living trust or a living trust. So understand those three things are the very same thing. And they are a legal document that does not get recorded with the court, with the state, with the county, or with the city. It is private. Okay. So it's not a public record, basically. This means that every detail that you designate in your trust is private and remains private. The public does not see who the beneficiaries are, what the beneficiaries are going to receive, what distribution requirements you have for them, whether you expect them to go to university or you're going to give a certain amount for their first house, or you want to incentivize them to open up a new business and you're going to give money for those specific things. All of those things are perfectly fine and they're perfectly private when they are designated in a trust. Okay. Any distribution instruction stays private. Any special provision that you've included in your family. And we all know that every single family is different. And because of that, has different needs. So whether you have a clause that protects your children from a future potential divorce, or a clause that incentivizes them to go to higher or advanced education, or to purchase a property, or to start up a business, or to stay away from any addiction because you are concerned about that and you want to prevent that from happening. All of those things are clauses that we can structure, that we can implement into your trust, and that are completely private. They are not public. They are not seen in court because there is no court when you have a revocable trust that is properly funded. That is the key here, that the trust be properly funded. So unlike a probate proceeding, which is what happens when you have a will or when you pass away with nothing, the probate becomes part of the public court record, just like divorces, just like criminal cases, just like civil lawsuits. Anybody can look it up and get access to it and to all the pleadings and to all the information and to the inventory and to all the asset lists because they're all public record. So a trust allows much of your estate and the administration of the estate to remain private. So let's talk about what does get recorded. What does get recorded, that is very important, is the deed. If you have real estate, whether that is your homestead, which means that is where you file for homestead exemption because that is your primary residence in Florida, or you have several properties that you rent out or use for whatever purpose, those deeds from those properties are those titles are deeded into the trust, and those deeds are recorded. That needs to be recorded. Okay. And that gets prepared by us. It's part of your estate plan binder. You sign it in front of a notary and in front of the witnesses. Then it becomes valid, executed, and then it gets recorded into the county where that property is located. The deed becomes part of public record because deeds are how ownership of real estate is documented. So that's important to know. The trust does not get recorded anywhere. It stays private the whole time. The deed to the real estate property is the document that gets recorded because that's what makes it valid and executable. So you record that with the county that applies to wherever that residence is located. So if you've got a condo in Miami Beach, that deed would be recorded in Miami-Dade County. If you have a house in Boca Raton, that deed's going to get recorded in Palm Beach County. And if you've got several properties in several counties, then they all get recorded in their appropriate counties. The county recorder's office does not receive a copy of your trust. That's very important to know. All they receive is the deed that is funding the trust, that is transferring the ownership of that real estate from yourself as a personal entity to you and your spouse or domestic partner, if that applies, as trustees of the trust. Still yours. You still have complete access to it. You have complete control over it. You have the ability to sell it, rent it, refinance it, etc. But now it is going to avoid probate because it is part of your revocable trust. So that's important to know. The clerk of court does not receive any of your healthcare directives or your trust. That's important. And your beneficiaries do not automatically receive copies of your trust either while you're alive, unless you provide that to them. Bottom line is, if your estate plan includes transferring any real estate property into the trust, the deed is the document that you want to record with the county where that residence is located. And your trust remains private. If you have any questions about whether your assets have been properly coordinated with your trust or properly funded into your trust, speak with your estate planning attorney. And if you don't have one, go ahead and give us a call or email us at info@familywealthlaw.net, and we'll be happy to help you.